Great. Good afternoon. Hello. This is Friederike Harnisch from ShareAction. I'm in London at the moment. I coordinate the European Responsible Investment Network, which is a network of NGOs and think tanks and trade unions that advocate for sustainable finance. It's called ERIN. Yeah, and one of our recent conferences, members have mentioned that they're really keen on more updates from other members. And of course, there's really excellent stuff going on across our network. So this is one of the first sessions through which we're addressing that. And we're kicking off with an exciting one. We've got ClientEarth, NGO that uses the law to achieve environmental outcomes. And ClientEarth is an ERIN member and a close ally for ShareAction in the pension field, some of which will be talked about today. So ClientEarth today will talk about the benefits of using legal approaches to achieve better climate risk disclosure, both by companies and by pension funds. And they'll share some learnings from the UK and also some ideas on how to replicate this work in other countries. And we've got two great speakers from ClientEarth, Cooke and Daniel Wiseman. I'll let them introduce themselves in a minute. But before handing over, just a quick note, this is meant to be very participatory. There'll be time for questions. Don't be shy. You can use a little hand sign flag if you've got a question, and then we'll unmute you. But I think you can also type in questions, and always good to mention your name and your organization. But without further ado, I'll hand over to David and Daniel.
Great, thanks very much, Friederike. Just checking everyone. Everyone can hear, as in you can hear.
We can hear you really well.
You can hear. Fantastic. Okay. Well, thanks for the intro. Yeah. So we are going to talk a bit about the benefits of using a legal approach in campaigns. We're going to talk about two sort of key areas that we work on. One is around corporate reporting, which I'll speak about, and then the other is around pensions and our work there, which Daniel will speak about. So I'll speak first, and then we'll have a sort of opportunity for a few questions, and then Dan will deal with the pension side. So yeah, I guess this this sort of webinar sort of stemmed out of a presentation at the ERIN conference last year, which, as already mentioned, was about the benefits of using a legal approach in campaigns. It's worth pointing out at the outset that we are talking about campaigns related to corporate and financial sector only. That sort of won't be a surprise to you as members of the ERIN network. But of course, legal approaches can be used in other campaigns. So from my side, I'm going to talk a bit about ClientEarth, give you an introduction to us and the company and financial project if you don't know about us already. Quick sort of general exposition of sort of the benefits of using a legal approach in campaigns. And then, as mentioned, ClientEarth legal interventions in the UK, split by corporate reporting and pensions. And then sort of most importantly for you guys is sort of the opportunities for replicating the same sort of thinking, the same sorts of legal interventions in the EU. So ClientEarth, it's no surprise that we think a lot about the benefits of using a legal approach. We're a non-profit environmental law organisation, so we have staff of lawyers, policymakers, scientists, etc. We use law, science and policy to tackle key environmental challenges, and across ClientEarth we work on climate change, energy, environment, justice, biodiversity, forests and human health. So lots of programs on different sort of environmental issues. But both Dan and I work in the company and financial project, and that is a project which uses corporate and financial law to drive greater integration of climate-related financial risk into management decisions of organizations. So I mean, a very sort of similar objective to lots of other NGOs in the space. It's to use legal interventions to speed up the low carbon transition. And we're talking about corporate reporting and pensions today, but we've got work streams around directors' duties, corporate lobbying, professional advisors, shareholder resolutions, a lot of the different themes and issues that you see in sustainable finance. We sort of, if we're not working on it already, we'd certainly like to be working on it. So just very briefly about the benefits of using a legal approach. We're all familiar with campaigning for environmental causes, but it's our view that campaigns become much more powerful if they're backed by the power of law. And a carefully chosen case or series of cases is itself a campaign, using the courts to enforce the law. But also use of the law to enforce environmental rights and other rights, in fact, helps build civil society. And it allows other groups and individuals to make a difference as well. From the perspective of a civil society organisation, you know, subject to all the sort of usual constraints in terms of funding, capacity, personnel, etc., I think there's 3 key benefits of using a legal approach. One is that in terms of the audience who we are trying to influence, that legal compliance is a foremost concern of many organisations. So if we can use legal arguments, legal authority to support advocacy, then these organisations are much more likely to take notice. I guess that sort of stands to reason. But more concretely, more tangibly than that, in relation to financial and corporate organisations, if advocacy has a legal flavour, then that actually might mean that it gets through to the corporate governance function, for example, and senior management that bit quicker. So I guess that's a sort of statement which is somewhat self-evident, but also actually when sort of picking it apart a bit, it means that sort of the interventions are that bit more effective. A key one is all parties are equal before the law, so it doesn't matter whether a civil society organisation is poorly funded, it has the same legal standing as any other organisation. And then the third point, which is actually what we're sort of trying to do ourselves, is activating the state and or the judiciary. And that obviously means that organs of state are activated on our behalf and can do our work for us. So in the case of a regulatory complaint, for example, if it's sort of likely to lead to a much more sort of comprehensive investigation than private research. So that's another sort of key advantage to using a legal approach. So, I mean, everyone, I would imagine, has seen some sort of variant of this slide, which deals with sort of climate risk and why it's a financial risk for organisations. But from a legal perspective, it's particularly important. Most of our work focuses on the concept of climate risk as a material financial risk, because that means it can be incorporated into the established legal framework for corporate and financial law. So that's a sort of somewhat of a sort of cornerstone of our work. But generally falls into the 3 broad categories you've seen on the slide here. And you know, there's a lot of momentum on this issue, a wealth of evidence about the financial materiality of climate risk. We've got the Bank of England report, which came out well in 2015, so nearly 3 years ago, on the impact of climate change on the UK insurance sector. We've got various matters both live and finished with the New York Attorney General. So there's the whole sort of Exxon matter, but also there was the Peabody case, which also has had a real sort of catalyst effect in terms of climate risk as a material financial risk. We've got the recommendations from the Task Force on Climate-Related Financial Disclosures and various sort of sustainable finance initiatives in the EU. So all of that means that climate risk is a material financial risk. And as I said, this is something of a cornerstone of our legal work. So we're going to talk today about legal strategies we've been working on in two key areas. First is corporate reporting, which has a focus on listed companies in carbon-intensive sectors. So far, we've focused on oil and gas, but the arguments we use could apply to organisations in the auto sector, utilities, insurance, banks, any organisation which has a business model reliant on continued use of fossil fuels or providers of finance to those organisations. And the second is pensions, which with more of a focus on the other side of the problem, i.e. investors and providers of finance to companies in carbon-intensive sectors. So in the corporate reporting space, we've been working on regulatory complaints to the regulator here in the UK. Now, improved narrative reporting is part of the broader policy push for better corporate governance and shareholder empowerment to drive and regulate corporate practice. The sort of premise for the work is if shareholders are to play this role, then the right kind and quality of information must be disclosed. And of course, that means disclosure is a key part of corporate accountability and a key point of intervention for civil society. And of course, it's very regulated by legislation. So in the UK, the Companies Act 2006 requires companies to provide a strategic report alongside the financial statements in the annual report. And that is the equivalent to the management report required by EU legislation, which I'll mention in the next few moments. During 2016, we submitted regulatory complaints in respect of two oil and gas companies, Socco International and Cairn Energy. And these regulatory complaints alerted the Financial Reporting Council, which is the financial regulator in the UK, that by failing to adequately cover climate risk, both companies' strategic report failed to satisfy specific reporting requirements for disclosure of, as set out on the slide there, the main trends and factors likely to affect the future development, performance, and position of the company's business, a description of the principal risks and uncertainties facing the company, information about environmental matters, and a fair review of the company's business. So those complaints were submitted in 2016. Since that date, both companies have released new annual reports, which have much better disclosures on climate risk and how climate risk considerations fit into corporate governance. While the matter was resolved between the FRC and the companies without the need for formal enforcement procedures, we believe that the process of submitting the complaints and the triggering of oversight by the FRC led to this improved reporting. It's also worth noting that we hope these complaints would shift the dial in terms of corporate reporting of climate risk more generally, i.e. sort of have a wider effect than solely in relation to those companies themselves. And there have been a few signs of this. I think there was a lot of media attention at the time the complaints were submitted. We have heard anecdotally that Magic Circle law firms are aware of the complaints, for example, and obviously those sort of law firms would be advising other organisations on these issues. And recently, the FRC has released a consultation on its guidance to the strategic report, and that now explicitly refers to climate risk in a number of areas. So I think, you know, there's a few signs that the regulatory complaints have contributed to increased attention being given to climate risk by the regulator and by others, such as the law firms I mentioned. So this, I guess, is a sort of the crux of corporate reporting in an EU context, is that the equivalent to the strategic report in EU legislation is the management report, which public companies are required to publish each year. And the accounting directive, as amended by the non-financial reporting directive, sets out the content requirements for that management report. And very simply, those content requirements for the management report in the EU are very similar to the UK strategic report. As you can see on the slide, there's the same requirement for a fair review, the same requirement for a description of the principal risks and uncertainties, and there is a similar requirement about likely future development. So I guess the point being that given that there is the same reporting requirement across the EU, although I've mentioned here is the accounting directive, and obviously there will be national implementing legislation in each country to implement that directive. But given that there's the same requirement across the EU, then effectively the same type of argument that we used in the UK in relation to climate risk for an oil and gas company could be replicated. So for relevant EU carbon intensive companies, the management report should cover climate risk as it should in the UK, and the arguments we made in our regulatory complaints can similarly be made for the management report. Also worth noting that, you know, whilst I've set out the accounting directive requirements there may well be additional reporting requirements in your country. So it's worth keeping an eye out on national legislation as well, national corporate governance codes, for example, listing rules. There could be much more reporting requirements in your national legislation than is reflected solely in the accounting directive in the EU. So that's, I guess that's it on the corporate reporting side. This last slide is about a few considerations you might like to think about if you were thinking about replicating this sort of argument in your own country. So the key one is, you know, who's the financial regulator who is charged with oversight of corporate reporting, and what are they saying about climate risk? You know, if they're making sort of positive statements or not saying anything at all, that I guess will sort of impact on your sort of initial approach to that regulator. For example, we had an ongoing engagement with the FRC in relation to climate risk before submitting the regulatory complaint. So we had they were aware of us and what we were sort of saying on the issue before the regulatory complaints were submitted. Also, you know, there will be sort of variations by different country as to the process for submitting a complaint to the regulator. Each regulator may well have its own operating procedures, who it can accept complaints from, that sort of stuff, which will impact on your sort of workflow. For example, it might be that an investor would be the person to submit a complaint, in which case there may be a need to sort of get some investor allies who will complaint. Other means by which to engage with the regulator. So a lot of our work is on responding to consultations. As I mentioned, there's been a recent consultation on the guidance to the strategic report here in the UK. there may well be sort of similar guidance documents and so forth in your own country. Also, a key sort of point of engagement is corporate governance codes, which, whilst notionally directed at corporate governance rather than reporting, they very often have actually reporting requirements in them, and certainly have a substantial degree of overlap with reporting requirements. So to the extent that they are consulted on as well, that's a good sort of port of call. And then I guess ultimately it's about sort of finding it's about which companies would be suitable targets for they are reporting, when they should be reporting better. What is their sort of reputation? Would they make a good target in the sense that there's been previous failures around corporate governance or other matters like that? So that's a few considerations, but there can be many more. For example, not on the slide is sort of communications around submitting a complaint and whether that can be used to leverage the impact of the complaint. But I think I'll stop there, and we can have a few questions before I hand over to Dan to talk about pensions.
Yeah, well, thanks, Dave. That's a good idea. Love to take questions now, so please raise your hand if you've got any experience with this type of work in your own country. Very open to you sharing your experience there. We've got Joel. Yeah. Are you self-muted, Joel? So you need to unmute yourself. Oh, right. Now we can be able to hear you. Sorry.
All right. Yeah, just to say, when you mentioned at the end that an investor can make the complaint, I guess from that you could be a very, very small investor indeed.
Yeah, I mean, I guess, ultimately, yes. I mean, we tend to talk about investors as just a sort of homogenous mass of organizations which are all very similar, but as you rightly point out, they're very, very sorry, our screen just went blank, so I had a bit of a panic. I was cut off. Everyone still hear me?
Yeah.
Yes, okay. Yeah, apologies. So yes, I mean, it's I guess the key question is impact, right? And obviously, unfortunately, the larger the investor, the larger the assets under ownership or assets under management, or whatever metric you're using to sort of quantify the impact, that is the better. So that's key. I guess we see a lot of engagement by investors though on this issue. All the sort of the largest investors in the UK are very active in this space, very sort of vocal in relation to climate risk. But also, some investors have slightly different positions, and some are, have a stronger position on a certain issue, so it's quite a sort of difficult to provide an answer to that. I'm also conscious I'm not being very clear, but effectively, small investors can certainly do it. But I guess to achieve maximum impact, then the larger the investor, the better.
But how
does that answer your question?
Yes, great.
Yeah, I was just wondering how easy you've found it so far to get large investors to do this, given that it's quite a public-facing action to take, and that might not be the preferred route of action for many of the mainstream investors.
So just to be clear, in relation to the regulatory complaints themselves, we submitted those in our own name without investor support. In the UK, we have standing to do that. We're an NGO. We don't have shares in the company, but nevertheless, through our engagement with the FRC and these operating procedures generally, which are to accept complaints from members of the public, that means we can submit these complaints in our own right. Other regulators may have a different stance on that, which is why I'm saying that it might be good to get investors to submit a complaint. We obviously let that sort of investor contacts know that we had submitted the complaint, and our anecdotal evidence is that they were very supportive in their own engagement with the FRC, but sort of potentially sort of that's slightly less public facing than you might have thought based on my presentation. But also, the regulatory complaints themselves. But for example, on other areas, investors are much more sort of are very happy to sort of put their own names to it. So, for example, another piece of work we helped coordinate was a position paper which was sent to the FRC on a new reporting requirement here in the UK for the viability statement, and pointing out that many oil and gas companies weren't sort of really complying with the sort of full extent. We had a lot of those papers. So I guess it sort of depends on the specific intervention that you are doing and what would be the investor appetite.
Great. Do you have any other questions on this section? Otherwise, we'll move on to pension funds. Cool. I think we're good to go to the next section.
Great. Okay. In that case, I'll have a bit of a talk about our pensions work. So I'll talk about the side of our work that I guess seeks to address the other side of the equation, which is investors who provide finance to companies in carbon-intensive sectors. I'll focus on our work on pension funds. I think pensions don't necessarily always strike people as a topic, but hopefully for this audience that's not the case. And I think the important thing from our perspective is that pension funds in Europe control multiple trillions of pounds of assets, and how these funds are invested and how the investors engage with the companies they invest in can have a huge influence on the behavior of those companies and how capital is allocated across the financial markets. So our starting point when looking at how to engage with the pension sector was really initially to do, I guess, look into what does the law actually require in relation to the duties of those who are managing pension funds. The pension sector in the UK is reasonably complicated in terms of a regulatory landscape. There's high levels of intermediation, and there's a number of regulatory regimes which apply to different parts of the market. So after doing a sort of a review of the relevant legal landscape, we identified an area of the market with legal requirements that we thought were the most useful for us to pursue. And that was in the UK, it's called benefit pension schemes. And they have quite clear legal requirements.
Would you mind repeating the last sentence or so?
Oh, sorry, you couldn't follow that?
The connection broke
okay, right, sorry about that. So in the UK, we focused on a particular segment of the market, which has quite clear legal duties that are relevant to climate change, broader environmental, social issues as a financial risk. And that duties are on the slide there. And so for the defined benefit pension schemes in the UK, trustees of those schemes have clear duties that assets the scheme controls must be invested in the best interests of members and beneficiaries. It's quite a broad legal duty, but guidance is subsequently provided by the relevant regulator, which frames what trustees are required to do to achieve that requirement. And that requires that decisions relating to investments must take into account factors that are financially material to investment performance. That's regardless of whether or not that factor might sometimes be regarded as an environmental or governance factor. This guidance, I think, has been really important in sort of affecting the understanding of the duties of trustees in the UK pension sector. Typically, I think in the past, legal duties have been seen as a barrier to trustees taking into account environmental and social issues. But when, I think, based on the work that's been done by others, particularly identifying climate change or other environmental social issues as having a material financial impact, that's allowed that legal duty really to be flipped on its head. So when framed as a financial risk or having a material financial influence, it then becomes incumbent on trustees or managers of funds to take those risk factors into account when they're making decisions. So despite that guidance from the regulator, I think it's fair to say that there's still a significant degree of confusion about what is actually required of trustees of UK pension funds in relation to ESG issues and climate change in particular. So to address that gap, in the course of our work, we decided that greater clarity would help move this conversation along. And we commissioned a legal opinion by two leading pensions barristers, which I think has been an incredibly useful tool for us to refer to in all of our future advocacy work. And the opinion that they've provided has made quite clear, it's up there on the slide, that in their view, if the risks associated with climate change are financially material to a particular investment decision, then it is clear, they think, beyond reasonable argument that the law permits and requires the trustees to take those risks into account when making that investment decision. They also pointed out, it's not up there on the slide, but that further in relation to that view, is that trustees of pension funds are obliged, when a matter is raised with them that is obviously fanciful, to turn their minds to whether or not it is financially material. So in their view, where the trustees are made aware of a potentially material financial risk, they are under a legal duty to at least consider whether or not that is a risk to their to the scheme. And if it is, then they are under a legal duty to take that into account in their investment decision making. So having considered that trustees of pension funds do have legal duties to take material financial risks into account, and where climate change is a financial risk, they will therefore need to take that into account in their decision making. There's a further question about what exactly taking that information into account requires. In the UK, pension fund trustees are primarily responsible for high-level strategic questions. So they generally don't make decisions, day-to-day decisions about specific investments themselves, but delegate those decisions to separate fund managers. Nonetheless, they do have a range of responsibilities and overarching duties where climate-related risks will be directly. So we've listed a number of these up on the slide there, and they're drawn from a range of other commentators who've identified similar issues. So the first is that trustees will have duties to consider climate change risk when they're setting overall investment strategy. And I think this is a particularly relevant point, because what is included in the investment strategy then serves as the legal touchstone for the rest of the decisions that the trustees are making. They are required to take climate change risk into account, determining strategic asset, making strategic decisions about asset allocation between different asset classes, between different sectors that they're investing in, between different geographies that they're investing in. They'll need to take climate-related risks.
Sorry, you were again. You broke off. So if you don't mind saying again, last 1 minute. What's that?
Sure. Trustees have duties in relation to setting overall investment strategy, which is particularly relevant given that the investment strategy document of a scheme serves as the legal touchstone for a lot of the rest of the decisions that that scheme makes. Climate-related risks are potentially relevant for strategic asset allocation, which can include decisions about allocating assets between different asset classes, as well as sectors and geographies. There's duties that they might have in relation to monitoring risk to their portfolio, which is reasonably self-explanatory. There's duties they'll have in relation to selecting asset managers, to putting contractual terms into their mandates with the asset managers to consider climate risk, and also to monitor the extent to which those asset managers are actually considering climate change risk where they've required them to do so. And finally, there's also potential duties that they might have in relation to stewardship activities, which I think is a particularly relevant point given the power and influence that we're increasingly seeing stewardship activities having over the behaviour of large fossil fuel companies. So, having sort of given a bit of an overview about the legal landscape, I'll turn to the legal intervention that we developed and prepared to push this, or at least to make the pension sector across the UK more aware of these issues. So we identified that despite what the law says, there's still very much a low uptake of the consideration of climate change related issues by UK pension funds. And so in order to leverage that sort of background research, we developed specifically legal intervention in relation to a particular sector of the UK pensions market, being the local government pension schemes, which is the LGPS, is the acronym. So we worked closely with ShareAction in relation to the LGPS, and we worked with ShareAction to help members of LGPS schemes to their pension scheme, basically just to ask them what related to climate change action and how they were managing climate-related risks.
Sorry, Dan, you broke off again. Dan?
LGPS schemes.
Sorry, Dan, we can't hear you. If you don't mind repeating.
Sorry, I'll go back if you can hear me now. Sure. So, by way of background about the work we did in relation to the LGPS. So we worked with ShareAction, and we helped members write to their pension schemes and basically to ask them and obtain information about what their scheme was doing in relation to climate change and how the scheme was essentially in response to the writing process, we received a range of responses from the different pension schemes.
Really sorry about this, but the connection is incredibly bad. We can't hear you, Dan. Is there anything you can improve on your connection? I think it might be.
We're just checking from our end. If you can hold on, if you can bear with us 1 minute, we'll just have a look.
Okay. Apologies, everyone.
Is that better now?
Yeah, it sounds better.
Trying to tweak a few plugs. Okay, hopefully that's an improvement. Sorry about that, everyone. I'm not quite sure what you have and haven't heard, but if I go back to talking about basically the referral we made in relation to the LGPS and the letter writing process, we inquired, so worked with shareholders or worked with pension fund members to write to their pensions and ask them what they were doing about climate change. And we received a wide variety of different responses in relation to those requests. Out of those responses, we collated them and we identified really 5 misconceptions that we saw as the pension funds holding in relation to what the law required of them. We've included them on the slide there. I think for present purposes, it's the top 2 that are really the most relevant. The bottom 3 are quite UK specific. But one response that came back frequently was that climate change does not pose financial risks and is only an ethical investment issue. The second one was that by delegating investment decisions to external investment managers, the LGPS thought it had discharged its legal duties to address climate change risk. So based on what we saw as those misconceptions, we prepared a referral to the pensions regulator, which is the relevant regulator in the UK. We explained the process that we'd gone through in relation to preparing the referral, and we set out the misconceptions that we'd identified, as well as our responses to why we thought they were misconceived. We pointed to a range of evidence now that shows that climate change clearly is widely regarded as a financial risk. And we pointed to reports by the likes of Mercer and BlackRock and the Bank of England and the other evidence that Dave mentioned earlier. And we also highlighted a range of evidence that showed that investment decision-making duties couldn't simply be delegated to investment managers because climate change-related issues had an impact at the portfolio level, so they were relevant for strategic decisions that trustees were making. So we prepared the referral and submitted it to the pensions regulator. Following that referral, the regulator conducted an inquiry process with the relevant pension schemes. They invited us to meet with senior staff to talk through our work. We also leveraged the referral for a range of different media opportunities and gained significant media coverage, hopefully to raise awareness about this issue across the pension sector more generally. Subsequently, over the preceding timeframe, we've seen triple the number of investment strategy documents from LGPS schemes considering and talking about climate change related risks to what we saw previously. We've also worked with a range of other bodies to help them prepare guidance for trustees on these issues as well. So the work we built into the referral has allowed us to leverage that subsequently and help really develop capacity across the sector to be taking these issues more seriously. So that's, I guess, an overview of the approach we took and really the outcomes we've seen so far. I think it's important to say there's still significant work to be done. Other parts of the pensions market still are definitely not considering climate change related risks to the extent that we believe they should be and are required to be doing under what the law currently requires. We're developing further referrals in relation to other parts of the pensions market. And we're also doing a range of work around informing professional advisors who are advising these pension funds about the legal duties of the pension funds and also their duties to be advising them. So that includes providing guidance and writing reports and doing seminars with lawyers and investment consultants and actuaries and asset managers to make sure that the whole industry is all joined up and on the same page. So in terms of thinking about what you might, the sorts of issues you might need to consider if you're looking at similar work in other jurisdictions, I think pensions requirements in different EU jurisdictions, the markets can be quite different, so you do need to look quite closely at what the particular law requires in your jurisdiction and who the financial regulators are, and whether or not they provide any guidance on climate change related issues or ESG issues more generally. You need to look carefully at what the process is for submitting a complaint and what sort of actors are empowered to do so. So similarly with the corporate reporting work, identifying the relevant actors is crucial. It's also worth thinking about how else you might engage with the regulators and whether there's other options for approaching the regulators in an informal capacity to ask them how they're approaching this issue, or to work with concerned pension fund members to approach them directly. The last thing is perhaps worth thinking about is who might be able to support these complaints, what other resources and capacities are there locally. I think in preparing this, it was very important for the work that we were doing to partner with ShareAction on this, to be able to reach out to their networks with existing pension fund members and to be able to really join up the pension fund member campaign with the legal regulatory complaint campaign. So that's another thing I think that's worth thinking about. I think that's a broad summary, but certainly happy to answer any questions that you might have. To the extent that you were able to hear, or if there were gaps, I can certainly answer them now.
Great. Question by Jack. Just 1 second, Jack. You can ask it now.
Hi, it's Jack Pollock from WWF UK. Thanks so much for a very interesting presentation. I wanted to ask on the guide that you mentioned that you brought out after a referral from the local pension funds. Is that also targeted at private pension funds?
So the guide that I was referring to is one we worked on with the Pensions and Lifetime Saving Association.
Yeah, I think I've read
and that. So that's targeted very broadly at the entire UK pensions sector. So it's set out in very general terms, but is intended to apply both to the public sector and private sector pension fund market in the UK.
Yeah, and just in terms of like it's really helpful and a good introduction for pension funds that may have thought a little about it or sort of as an introduction. Would you say that there's any leaders that might be a bit more advanced than the guide?
I think the guide, as far as I recall, does include a range of examples of current sort of leaders in this space. In terms of pension funds doing the most work on this that we see, I think the Environment Agency Pension Fund is widely seen as sort of very much setting the benchmark for taking climate change related risks into account, and they've got all of their information on their website, which I think is incredibly useful. There's a range of private sector pension funds that have now, I think, directly adopted or included climate change related considerations in their strategies as well. I think the obvious ones are the HSBC Staff Pension Fund. Now it's a contract-based pension fund, and the option offered this now sort of what they call a climate tilted index-based fund. There's a range of examples, and certainly happy to talk with them if it's useful.
All right, great. Thank you very much.
or perhaps follow up and send them through separately.
Yeah, that'd be great. Thank you.
Right, do we have any further questions or comments, interest in your country to pursue these strategies? No? Are there particular countries you're interested in exploring these strategies you've explained further, or are you just quite open to wherever it takes you?
From ClientEarth's perspective, in relation to the pensions work, I think the majority of our work is certainly focused on the UK so far, and I think there's a range of work that will continue there. We're still in the process of, I guess, scoping other relevant jurisdictions. So we're definitely looking to expand some of this work and seed some of this work in other parts of Europe, and to support that to the extent that we can, where we can partner with other organisations to do some of that work as well. Yeah, the short list of likely countries, I think we're still developing, but Dave might have a comment on that as well.
Yeah, I guess from a corporate reporting side, it's a bit different. Like there is variation in pensions law and pensions market, much more so than in corporate reporting requirements, and so it's really sort of where are the sort of the companies which are reporting most poorly, and where the sort of highest impact could be had by sort of moving the dial in that jurisdiction to have better disclosure practices. So we know that the law's similar across the EU, so it's about sort of choosing the it's about sort of working with the jurisdictions where the most impact could be had.
Good. Now, you generally open to be approached by organisations in different countries who are quite interested in discussing this further?
Absolutely, yeah. We'd encourage anybody, if this has sort of planted a germ of an idea in anybody's heads, then please do get in touch with us. We'd be very happy to talk in much more detail about any of these aspects, or indeed sort of any of the other work we do, for example, shareholder resolutions and directors' duties, etc. So we'd be really keen to talk further if anybody is willing to talk to us.
Right.
Thank you very much, everybody.
Thanks.